Good afternoon, everyone. Thank you for joining us today. I'm Clare Norins. I direct the UGA First Amendment Clinic, and I'm also a board member of the Georgia First Amendment Foundation, which is the sponsor for today's program. And presenting with me this afternoon are Lindsey, Floyd, and Jack Beaman. So I'll briefly introduce them before we get into the substance of our presentation. So Jack is a second-year law student enrolled in the UGA First Amendment Clinic. Before and during law school, Jack worked at a Washington, D.C. law firm focusing on white-collar defense and representing clients involved in government investigations. Jack received his undergraduate degree from the University of South Carolina, where he interned for the South Carolina State Attorney General's office, and he was also a contributing writer for Real Clear Sports, an online sports publication. Lindsey Floyd is a legal fellow with the UGA First Amendment Clinic. She is a 2021 graduate of the University of Colorado Law School and a member of the Colorado Bar, and today just learned that she passed the Georgia Bar, so congratulations, Lindsey. She received her undergraduate degree from Arizona State University, and while in law school, Lindsey represented low-income clients in employment and housing litigations. She interned with the ACLU of Colorado, and she was a fellow at the Byron White Center for the Study of American Constitutional Law. So we're going to give you a little roadmap of our presentation today before we dive right in. So next slide, please. So we're going to focus on three areas of court access in Georgia. First, we're going to talk about access to court proceedings in both state and federal court. Then we're going to talk about access to court records or court files in state and federal court. And finally, we're going to talk about gag orders. So during our relatively short time today, we are able to give you the broad strokes in these three areas. But for more detail, we encourage you to check out the Yellow Book Guide to Court Access in Georgia, which is published by the Georgia First Amendment Foundation in collaboration with the UGA First Amendment Clinic. So let's start with the threshold question of why is court access important? Why do we care about this issue? As Chief Justice Burger of the United States Supreme Court wrote in 1980, the public's right to see and observe court proceedings is no quirk of history. There is a long tradition in our country of public access to the courts, and it serves several important functions. First, public trials have significant therapeutic value for our communities. They allow an outlet for community concern, hostility, and emotion. In other words, they provide an alternative to violent self-help and vigilante justice. Second, for people to have trust in our judicial system, they have to be able to see how it's working. They need to be able to understand and accept, this helps them understand and accept the outcomes of legal cases, even if they don't agree with the outcome. And finally, and perhaps most importantly, public access to courts safeguards the integrity of the judicial process because it allows the public to serve as watchdogs against perjury, against prosecutorial and judicial misconduct, and other violations of the right to a fair trial. So with those lofty purposes in mind, the right of public access to the courts is grounded in three types of law. We have common law, which is historical custom and court decisions. We also have the Federal First Amendment, which protects freedom of speech and press, among other expressive freedoms. And then we also have the Georgia State Constitution, which protects the right of every person to speak, write, and publish on all subjects. So with that background, I'll now turn it over to Lindsey to talk about access to court proceedings.
Thanks, Claire. So today we're going to discuss your public right of access to court proceedings in both state and federal court in Georgia. But before we can discuss this right, I want to give you a brief overview on the structure of Georgia courts. So in both state and federal courts, you have trial level courts, and this would be the Superior Court in state court and the district courts in federal court. Those courts appeal to the appellate courts. So the Georgia Court of Appeals and the U.S. Court of Appeals for the 11th Circuit. The highest appellate courts are the Georgia Supreme Court and the United States Supreme Court. So when we discuss federal court in Georgia, we're discussing the 11th Circuit, which is the appellate court that hears cases from all 3 district courts in Georgia, as well as the district courts in Florida and Alabama. So now that you have a better understanding of our court systems, let's first talk about which court proceedings are open to the public. So in both Georgia state and federal courts, the following proceedings are open to the public and the press. It includes pre-trial proceedings, civil trials, criminal trials, post-trial proceedings, and appellate proceedings. So as you can see, you have a broad right of access to court proceedings in Georgia, and this aligns with the long-standing history of affording public access to our government. When can civil proceedings be closed to the public? So the court distinguishes between partial closures and full closures of the courtroom. A full closure occurs when a courtroom is closed to everyone, but the lawyers, the parties, the witnesses, and the court personnel. No one else is allowed to observe. A partial closure would be a limitation of access during a particular witness's testimony, or only allowing some people in the courtroom, but not the general public. In state and federal court, civil proceedings may only be closed when the closure can pass strict scrutiny. Strict scrutiny is the highest standard of review that we have in the legal system, and it requires that the closure is narrowly tailored to serve a compelling interest. So the interest must be very strong to justify a court closure. In federal court, a court may only grant a partial closure if there's a substantial interest. So this is still a high standard, but it does require a little bit less than strict scrutiny. So for example, a federal court granted a partial closure to protect the dignity of a witness who was testifying about being forced to perform sexual acts after witnessing the murder of her partner. The partial closure of the courtroom only allowed the press and the family members of the parties during her testimony, but the courtroom was open for the rest of the trial. So that's an example of when the court found that there was a substantial interest to justify court closure in federal court. So when can criminal proceedings be closed to the public? In state court, criminal proceedings may be closed to the public if closure is the only way to avoid a clear and present danger to their right of a fair trial. The movement must show that there is concrete, tangible evidence of a clear and present danger. So for example, trial publicity is not enough to constitute a clear and present danger. In federal court, closure must again pass strict scrutiny, so a compelling justification and a narrowly tailored closure. For example, a hearing about the admissibility of graphic evidence in a child sexual assault case may have a valid, compelling justification for closure. But before the court orders a closure in state and federal court, the court must consider alternative means. So it would include isolating the jury from the public, also known as jury sequestration, or changing the trial location, postponing the trial, engaging in rigorous jury selection, or giving clear and emphatic instructions to the jury. These are all alternatives that are favored over a partial or full closure of a court proceeding. So now that we've talked about your right to actually access the courtroom, let's discuss what you're allowed to do while you're actually in the courtroom. So first, let's discuss your right to record. Whether you can record a state court proceeding depends on your role at the proceeding. So there's different rules depending on why you're there. So for jurors and witnesses, jurors must not have their phones, they must have their phones off during court proceedings, including during jury deliberations, and may only use their phones during authorized breaks. Witnesses must have their phones and electronic devices off during court proceedings and while testifying, unless they get special permission from the judge. So while they're actively engaged in the court proceeding, they may not use their phones or to record. For attorneys and self-represented parties, attorneys may make audio recordings, so not video recordings, but they may use an audio recording device, as long as it's not disruptive And as long as they announce to the other parties and the court that they plan on doing so before they actually start recording. And then parties and spectators may only use recording devices when submission of requests is approved by the judge. So let's talk about what that submission might look like. So spectators, and this would include representatives of news media, must submit an application to the court at least 24 hours before the proceeding that they would like to record, if it's practicable. The court will then notify the parties, the witnesses, and the victims about the non-party request to record to see if there's anyone that wants to object to the request. An objection is not dispositive of whether or not your request will be granted, but it's one of the factors that the court will consider. And then a judge must abide by a three-step process to deny or limit a recording request. And we actually have a really wonderful sample request to record in the back of the yellow book. So I highly encourage that you check that out. So what is the three-step process that the judge must follow? Well, first, the judge must make specific findings that there is substantial harm. So this is when the judge will start to look at the factors, like the nature of the proceeding, or if there was an objection, to decide on whether or not he or she may deny the request to record. Again, the judge will definitely weigh whether or not your right of recording is being upheld correctly when deciding whether or not to deny the request. Then once the judge finds, if the judge finds that there's a substantial harm, that harm must then actually outweigh the benefit of recording. So again, there is a strong presumption of access, and we know that there is a benefit to recording. So the judge may only deny a request to record if the harm outweighs the actual benefit of recording. And before the judge can deny the request in full, he or she must consider more narrow restrictions or limitations than outright denial of the recording request in its entirety. So for example, that would look like only being able to record a part of the testimony. So as you can see, this requirement works in your favor of your right to record in state court, because inevitably some harms will probably always exist, but those harms must outweigh the benefit of recording, and they must be substantial. So there are certain times when recordings in state court are prohibited as a matter of law. So those include when the judge is outside of the courtroom, during jurors' conversations or statements, with the exception that you may record when the foreperson is giving their verdict. You may not record during privileged or confidential conversations between attorneys and clients. So for example, if you're sitting really close to where the attorney and client is sitting at their table and you can overhear their conversations, you may not record that confidential conversation that's happening between the two of them. And then you also may not record during bench conferences. So this would be when attorneys approach the judge to talk about a matter in the trial. So now let's talk about recording in federal court, with the large caveat that it really does depend on where you are attending court. So in criminal proceedings, you may not photograph in or broadcast from the courtroom during federal criminal proceedings. And this is for all criminal proceedings, regardless of where you are. But civil proceedings have their own rules for each court. So generally, no, you may not record, but each court has different rules depending on the type of proceeding that's occurring or on where you're trying to record. So it's really important that you check out the local rules for the district that you're in before you attend a proceeding. So now that we've talked about recording, what about using your phone or your laptop for non-recording purposes, such as to take notes? So jurors, it again depends on your role in the court. Jurors and witnesses may not have their devices on them while they're present in a courtroom. And this is in state court. And so jurors and witnesses may not have their devices on them. Attorneys and self-represented parties may use their electronic devices for most purposes, as long as they're not being disruptive, right? So they can't use their phone to take a phone call or their computer to play a video out loud, but as long as they're not being audibly disruptive, they can use their electronic devices for most purposes. And then what really matters to most of you is parties and spectators. They may freely use electronic devices for non-recording purposes, so long as the judge believes that your use of that electronic device would not be disruptive or distracting. So you may in state court use your computer or your phone or your tablet to take notes or to do whatever you need to do, to send out stories, to tweet, as long as it's not going to be distracting in state court. This rule does differ from federal courts, and again, it does depend on the area or the district that you're in. So for example, the Northern District doesn't allow any electronic devices for any purpose. Those are prohibited inside of the courtroom, so you might as well not even bring them. But the Middle District of Georgia allows members of the press to use their electronic devices as long as they have press credentials and their devices are silenced. And the Southern District of Georgia does not have a rule, so it would be important to contact that court before you decide to attend that proceeding. So now that we've talked about your access to court proceedings, I'm going to turn it on over to Jack to talk about your right of access to court records.
Thank you, Lindsey. As Lindsey mentioned, we're now going to dive into access to court records, and I'll touch on both Georgia state courts as well as Georgia federal courts. Beginning with Georgia state courts, there is a presumptive right of access to court records. And in the words of the Georgia Supreme Court, and as you see on the slide in front of you, like a candle, court records hidden under a bushel make scant contribution to their purpose. So there's this strong belief articulated by Georgia's highest court that court records must be open to the public. And according to the court, such openness is to protect litigants both present and future, and to ensure the integrity and legitimacy of the judicial process. So in Georgia, there is a presumptive right to state court records under Rule 21, and this starts when a document is filed with the court, either in hard copy or electronically, and it applies to records at all stages of a case. So that would be before trial, during trial, after trial, as well as during any appeals that may take place. This presumptive right of access also means that all state court records are public and available for both inspection and copying, unless access is limited by a particular law or by the procedures set forth in Rule 21 of the Uniform Rules for Superior Courts in Georgia. So what is Rule 21? Rule 21 is the rule that protects the public's right to access Georgia state court records, and it sets out strict procedures that must be followed before documents can be withheld from the public or sealed. Rule 21 answers the important question of what even constitutes a court record to begin with. And the rule says that a court record includes filings that describe the claims or defenses in a case, make a request to the court to take some kind of action or to grant some type of relief, set out a decision or ruling by the court, or just contain information that is central to the ultimate ruling that the court makes. And so this definition of a court record includes most documents filed or submitted to a court. Documents related to a trial are also court records, and this would include things like evidence and exhibits used during the trial, as well as transcripts of the trial proceedings. Court dockets are also public, and a docket is the log of activity and filings in a case, essentially showing you what's happened in the lifespan of that case to the present date. If you do want to go and look at the court docket for a case, you must go to the website for the court where the case was filed or where the case is being appealed and look up the case by name or case number. If the particular court where a case was filed or is being appealed does not have electronic filing, you may have to call or visit the courthouse and request to see a hard copy of the docket sheet. Note that if you do request hard copies of documents, you may have to pay reasonable copying costs, which is generally 10 cents per page. So I've been talking about this presumptive right of access to court records because it's not an absolute right. Courts can actually restrict or prohibit access to court records in cases of clear necessity. Superior Court Rule 21 that I mentioned previously requires courts to follow a very specific process in order to restrict access or to seal court records. And this process involves 3 distinct crucial steps. So first, a party or even the judge in a case has to make a motion to seal some or all of the court records, and that motion has to explain the legal and factual basis for the motion to seal, And that includes an explanation that there is a privacy right that outweighs the public's interest in having access to the record or records. The party moving to seal the records has the burden to prove that their privacy interest is stronger than the public's interest in keeping those records open. Second, under Rule 21, the court has to conduct a public hearing on the motion to seal where the parties may be heard as to their respective arguments about whether the records should or should not be restricted from public access. And then third, the court has to issue its own order explaining why it is limiting access, or conversely, why it would be declining to limit access. If the court is limiting access, the order has to include a description of the court files or parts of the file to which access is limited, the nature and duration of the limitation, as well as the justification for the limitation. And when a party moves to restrict public access to court records, it is generally a losing argument to assert that the information contained is just embarrassing, or to assert generalized reputational concerns if that information becomes available. That is generally not viewed as a sufficient justification for sealing records. Instead, a court is more likely to find a weighty privacy interest when the particular records at issue have been previously acknowledged by the court as confidential in nature. So this would include, for instance, situations where the records are covered by a protective order in the case. In that situation, the court would be more likely to allow the records to be filed under seal. And other examples would include, as you can imagine, sensitive information like personal medical records or even mental health information. A trial court's order limiting access to court records can be appealed to the Georgia Court of Appeals, or an intervening third party like a public interest group or a member of the public or a member of the media can also move to unseal records when it is in the public interest for those records to be accessible. Generally, a reviewing court may grant a request to unseal a previously sealed court record if the moving party failed to show that privacy interests outweigh the public right of access, or if the court that sealed the records failed to follow the steps detailed in Rule 21. For instance, the trial court may have failed to hold a public hearing on a motion to seal, or may have failed to issue an order that adequately explained its balancing of interests that led it to either support or not support sealing the records. Or finally, if the documents have high evidentiary value, essentially meaning the documents are just particularly relevant to the legal issues that ultimately are deciding that case. So that wraps up access to Georgia state court records, and we'll now pivot to Georgia federal courts, where a lot of the same principles of openness still apply. In federal court, there's a presumptive right to inspect and copy judicial records and documents filed with the court, and a lot of the same kinds of court materials that the Georgia state court right of access to documents covers are covered here as well. So court dockets, transcripts of proceedings, pleadings, motions to resolve the merits of a case, and a judge's decisions are all examples of records the public has the right of access to in Georgia federal courts. There is some nuance, however, when it comes to discovery materials. So discovery materials are documents and information that parties produce to one another during the exploratory or investigative stage of a case, and that is called the discovery stage. A lot of these materials never actually end up being filed with the court or used at trial, and the 11th Circuit has held that as a general rule, the public does not have a right to discovery materials given their lack of submission to the court. That said, if discovery materials are submitted in connection with a substantive motion to the court, there is a right of access to those discovery materials. And this would be the case even if those materials were not ultimately central to the outcome of the case at hand. The case of Callahan v. United Network for Organ Sharing provides an example of how a federal court applied this rule. So the United Network for Organ Sharing had attached what it felt were embarrassing internal company emails to a briefing in the district court, and subsequently on appeal sought to keep those emails sealed from public view. The 11th Circuit stated that what matters is how the document was used by the parties to support an argument before the court, and not whether the court itself used the documents to resolve that argument. Moving on from discovery materials, the public also does not have a right of access to grand jury proceedings, and by extension, the public cannot access court records used or filed in connection with those grand jury proceedings. When a party in a federal case moves to seal court records, the federal courts use a balancing test to determine whether to override that initial presumption of public access. The party moving to seal court records must show good cause, which specifically requires balancing the public's right of access against the moving party's interest in keeping that information confidential. And this test covers a good bit of ground. As you see on the slide, a variety of factors are considered, including whether access would harm legitimate privacy interests, the degree and likelihood of injury if made public, the reliability of that information, whether an opportunity for response to that information exists, whether the information concerns public officials or public concerns, and the availability of a less onerous alternative to sealing the documents. With regard to accessing federal documents, most court documents in federal cases are filed in an electronic system that can be accessed through an online service called PACER, which stands for Public Access to Court Electronic Records Service. Note that although you can register an account for free, there are fees associated with every document you download. It is 10 cents per page downloaded and is capped at $3 for any document in its entirety. That said, you are afforded free downloads until you hit $30 worth of downloads, at which time those charges I mentioned kick in. Documents not available on PACER can be requested by contacting the clerk's office in the courthouse where that case was filed. And that wraps up access to court records in Georgia's federal courts. A reminder that in this presentation, we've covered the broad strokes of access to court records in Georgia. And if you do want more detail about access to records in specialized courts, so juvenile court, for instance, or probate court or business court, please be sure to check out our Yellow Book guide. I will now turn it over to Clare Norins. Thank you.
Thank you, Jack. So we're now going to talk about gag orders. And in the context of court access, if we could go to the next slide, please. A gag order is a judicial ruling that bans public discussion or publication involving information about a court case. So for instance, if a judge orders that the parties and witnesses in a trial are not allowed to publicly discuss certain aspects of the case, that would be a gag order. A gag order stops speech before it even occurs, and we call that a prior restraint on speech. Prior restraints are considered to be among the most serious and least tolerable violations of the First Amendment freedoms of speech and freedom of press. And so for this reason, gag orders are presumptively unconstitutional. This means that a reviewing court will start with the assumption that a gag order is unlawful and work backwards from there. So for a gag order to be lawful, the court issuing the order has to have a very good reason, a compelling reason for doing so. An example of a compelling reason might be the necessity of protecting a criminal defendant's right to a fair trial. And a right to a fair trial includes, among other things, the right to be presumed innocent until proven guilty, and the right to have your case decided by an impartial jury. But even when a gag order is intended to protect the very important right to a fair trial, the gag order still has to be narrowly tailored to achieving that goal. If there are alternative ways to protect the fair trial right without gagging people from speaking or publishing, then the gag order will be struck down as unconstitutional. So we're going to start off by talking about gag orders that apply directly to the press or to the media. Gagging the media is highly disfavored in both federal and state court in both criminal and civil contexts. The US Supreme Court has created a test for evaluating whether a gag order on the press in a criminal case is constitutional. And this test comes from the 1976 case, Nebraska Press Association versus Stewart. So in that case, a man was charged with murdering 6 people in their home in a small Nebraska town. And the criminal trial judge who was overseeing the accused man's trial was worried that publicity about this shocking crime would make it very hard to find a number of people who were impartial to serve on the jury. So the judge issued a gag order on news coverage of the murders until the jury had been selected. And the gag order, it stopped newspapers and other media from publishing descriptions of the accused man's statements or confessions or any other facts that strongly suggested the man was guilty. The Nebraska Press Association appealed this case first to the state Supreme Court in Nebraska and then finally all the way up to the United States Supreme Court. And there the order was struck down as violating the First Amendment, and we'll talk about why. So first, the Supreme Court identified 4 factors that a court should use when evaluating whether a gag order on the media is unlawful or whether it withstands strict scrutiny. So the first factor is the probable scope and nature of the pretrial publicity. Second, a court should look at what will be the likely impact of such publicity on potential jurors, because the Nebraska Press decision said that even when you have widespread and negative publicity about a trial, it doesn't necessarily mean that there's been a violation of the fair trial right. So you have to really scrutinize what is going to be the likely impact. Then you have to look at whether there are alternative measures that could be taken to cure or mitigate any prejudicial effect on jurors of people talking about or publishing about the case. And then finally, a court would have to look at whether the gag order is written in a narrow way that is practically enforceable. So for instance, in the Nebraska Press case, the gag order there said that there could be no publication of any information that was implicative of the accused man's guilt. And that word implicative is vague, and so it's hard to know what information would actually be prohibited under the gag order, which contributed to why the Supreme Court struck it down. But the core reason for striking it down was that the Supreme Court found there were actual alternative measures. If we could go to the next slide, please, that would have protected the accused man's right to a fair trial other than putting a gag order on the press. So those alternative measures were things like moving the trial to another location or postponing the trial until some of the public attention had died down, carefully questioning potential jurors to make sure they hadn't already formed strong opinions about the man's innocence or guilt, instructing the jurors on their duty to impartially and objectively evaluate all the evidence, and even sequestering the jury once they are selected. These are all alternative measures that Lindsey also talked about when she was discussing access to court proceedings. These alternative measures can be used in place of prohibiting people from speaking and publishing. So Nebraska Press is a really important case even today, and it was about a criminal case, a gag order on the media in a criminal case, but it in some instances has been applied to gag orders on the press in a civil case as well. So now let's look at a civil case in Georgia from 1981, where there was also a proposed gag on the media. So in this case, Georgia Gazette Publishing versus Ramsey, it involved a Savannah dentist who sued the Georgia Gazette newspaper for invading his privacy because they had published articles that suggested he was a suspect in a murder case. So the dentist was suing the paper, and the dentist asked the court to prohibit the paper from publishing any information that it learned in the course of defending itself against this privacy claim brought by the dentist. So the dentist did not want the paper to be able to share any information that the paper learned during the course of the case. And the Georgia Supreme Court rejected this proposed restriction on the newspaper. The Supreme Court, our state Supreme Court, didn't even bother with the Nebraska Press Association factors. It went straight to our own state constitution, and it said our constitution in Georgia protects the newspaper's right to write, speak, and publish on all subjects. And these protections must remain paramount, is what the Supreme Court said. And so it found that the gag order in this case was really an unwarranted restraint on the newspaper's freedom of speech and press. So this is another example of where gag orders on the media are highly, highly disfavored. So now we want to switch gears a little bit and talk about a gag order on the participants in a trial, such as the lawyers or the witnesses. Keep in mind that Jurors are always prohibited from talking about the case while they are sitting on the jury. That is standard practice for a judge to instruct the jurors that, when they go home at the end of the day and they're going to come back the next day to continue their service, that they're not allowed to talk about the case. So in this instance I'm going to talk about now, the jurors, of course, could not talk to people while they were sitting on the jury, but the court also wanted to prohibit the lawyers working on the case, the criminal defendant in the case, any of the court personnel who were, sitting in on the trial, as well as law enforcement personnel who were involved in the trial. All of those people were prohibited from talking. And this is the WXIA TV versus State of Georgia case from not so long ago, 2018. So here we had a gag order that was preventing people from allowing these TV stations to engage in news gathering because the TV stations were able to show that before the gag order had been issued, people were giving them interviews and were talking to them about the case and allowing them to report on the case. And after the gag order came out, people could no longer talk to the TV station. And so the court said that the TV station did have standing to bring a challenge to the gag order as a third party because the gag order was interfering with the TV station's First Amendment right to engage in news gathering. And at the end of the day, the Georgia Supreme Court did strike down this gag order as unconstitutional. And the reason being was that the court found no evidence of a reasonable likelihood of prejudice to the criminal defendant if people involved in the trial were allowed to speak to the media. And in this context, when I say prejudice to the criminal defendant, I mean there was no interference with his right to be presumed innocent until proven guilty or his right to be tried by an impartial jury. And the court said that you cannot infer a likelihood of prejudice to the defendant simply because there was a lot of media interest in the case. So this is a fairly recent case, as I mentioned, and it really reaffirms how disfavored gag orders are, even when they aren't directly applying to the press, but are still interfering with news gathering and freedom of speech and press freedoms. So the third context that we'll look at in terms of gag orders are family court cases. So here we have a couple of different decisions spanning the decades. So the Georgia Supreme Court has said that it is constitutional for a family court judge to prohibit parents who are engaged in a divorce proceeding from making defamatory remarks about each other in front of their children. This is a fairly narrow prohibition on speech, and it serves the compelling interest of protecting the best interests of the child. So that's a 1974 case. And then we have a more recent case from 2016, where the Georgia Court of Appeals struck down as unconstitutional a court's order that prohibited the parents involved in a child custody case from talking about the case on any social media, any website, or any other public medium until their child turned 18. And the Court of Appeals said this is a very broad prohibition on speech, and there was no imminent danger to a compelling interest that would justify such a restraint on the parents being able to speak or write. And importantly, the Court of Appeals also noted that the parents needed to be able to talk about the child custody case, even to criticize the judge in the trial, because operations of the courts and the judicial conduct of judges are matters of utmost public concern. And therefore, it's especially concerning when the speech being prohibited is about sort of the operations of the courts and the judge's conduct. So that gives you a sort of a sampling of how the courts have evaluated gag orders. One thing I'm sure you're all probably interested in, but which should really be a separate presentation, is what do you do when you have restrictions on court access in place that you want to challenge? So what if a court proceeding has been closed or a record has been sealed? So the first thing you want to do is figure out which rules and balancing tests and standards are going to apply to that particular situation that you want to challenge. And the yellow book will be a good starting point for figuring that out because, you know, as you can see from today's presentation, there's a wide array of different rules and standards and balancing tests. And so first you want to start with, were those rules followed? So particularly when you're in state court, if you're dealing with a sealed record, you know, that would be governed by Rule 21 of the Uniform Rules for Superior Court. If you're dealing with a situation where the judge said there couldn't be any recording in the courtroom, that's going to be governed by Rule 22 of the Superior Court Rules. And so you want to find out either from talking to the parties or looking at the docket sheet, were the procedural steps followed under those rules such that the procedure of the closure or the sealing was proper. Because if the procedure wasn't followed, that's a very good grounds for challenging the restriction. So ultimately, when you're challenging a closed court proceeding or a sealed record or a gag order, you are most likely going to need the help of an attorney to make a motion to intervene in the case, because if you're not already a party to the case, to get into it, you have to be an intervener. So you need to make a motion to intervene and make a motion to request that the whatever the restriction is, that it be lifted. And if it's a time-sensitive situation, such as a closed court proceeding that's scheduled to take place in the very near time frame, and you want to have access to it, you may need an attorney to help you make an emergency motion to be very quickly ruled on by the court before the proceeding has happened, and then it's kind of a moot point whether it was open or closed. So I give you that very brief overview of sort of how you might challenge court proceedings because we don't really have time to get into that fully today. But now we will open it up. If folks have any questions, we will do our best to answer them. And if we can't answer them here, we can follow up with you after looking into it further.